Today's conflict is between ethics and law, inclusive of the evolution of ethics and law relationship and their separation. Before you navigate the slides, I want to share a few introductory notes on history of separation of law as it is from law as it ought to be. In ancient Rome, the era that ended with the collapse of the Western Empire in the 5th century Anno Domini, the law was divided into written laws, jus scriptum, and unwritten laws, jus non scriptum. The unwritten law referred to the customs or today's moral codes, and the written law was about legislated laws and the common law. So in ancient Rome, ethics and law were already separated. The Romans were crispy thinkers who believed that law must be free from sentiment, shaming, or empathy, and in the meantime it should not be enforceable upon certain wrong or immoral acts. The jurisprudence differed in France. In the Napoleonic Code, enacted after the French Revolution, ethics and law were integrated and shaming and punishment were coupled. Much of the credit for this goes to the French professor of law, François Gény, who chiefly shaped the legal philosophy of the Napoleonic Code by advocating for judicial discretion or freedom to make own rules by applying juristic techniques, which he named construits, to the facts which he named dons, if the pre-existing written or unwritten laws failed to cover the given case or situation. The Napoleonic Code has had a vigorous influence on the laws of several continental European countries and Latin America, although its dominating power shrunk when the German Civil Code was introduced and adopted by Japan, followed by the arrival of Swiss Civil Code, which was adopted by Turkey after the dissolution of the Ottoman Empire. Today, the Napoleonic Code is still used in Belgium, Luxembourg, Monaco, the Canadian province Quebec, and certainly the state Louisiana that uses French Civil Code, unlike the other states that use British common law. For instance, Louisiana does not recognize common law marriages unless the marriage occurred in other states where such union is legal. Now, in the United States, ethics and law are separated, and among multiple reasons thereof is the practice of so-called legal positivism. This is a doctrine maintained by liberal justices, among them Oliver Holmes, the Boston-born Associate Justice of the U.S. Supreme Court, who was unusually cruel during the Espionage Act era in World War I. I have a separate presentation about it on this channel. The same justice who in Buck versus Bell of 1927 had infamously said 3 generations of imbeciles are enough. So Holmes wasn't a typical soft liberal justice. Rather, he was grossly controversial. Positive liberalism was established in 1832 by Austin, a British jurist, to baffle the multitude of sins in the context of separation of law as it is from law as it should be. In the modern era, the chief architects of this doctrine are Hans Kelsen, an Austrian jurist, and legal philosophers Hart and Raz, who claim that moral norms are valid only if they stem from divine commands or social conventions, and that ethics and law should be separate. Having that said, it's finally time to see the key principles and differences between ethics and law as provided on slide 3, namely that laws are enforceable yet the moral norms are not. In practical terms, because of such disintegration, a shameful or immoral act can be legal and a non-shameful act can be illegal. For example, adult filming, burning the national flag, whistleblowing are somehow shameful but legally protected acts in this country. On the other hand, breaching a contract or improper parking are not shameful, but those are illegal acts. The next slide outlines the main fields of ethics, and slide 5 explains how are ethics and law separated by process, subject matter, and penalty. You will read the details later. An equally important question is why are ethics and law separated? Explanations of my view follow. Here I share modern-day examples of ethics-law conflicts, including the fallacious cases brought against the former President Trump, in particular the so-called hush money case where the extortionist Clifford is given a green light. She's not being punished for her factual blackmail, which is a federal offense. rather is recruited by the prosecution to sink Trump over a time-barred fallacy and without any victim. Other conflicts are seen in cannabis legalizing cases or in cases where homeless people who sleep in the parks or sidewalks are prosecuted. The outlined cases are about ethics and law conflicts around active euthanasia, coroner autopsy and organ harvesting, or legal malpractice. Conventionally, the last section is a quiz followed by the answer key on slide 17. Now it's time to part, and I hope you'll benefit from a self-guided study. See you next time.